All right. Good afternoon, everyone, and welcome to our final in the boardroom for 2024, where today we're going to talk about town withdrawal from county zoning. Before I turn it over to our presenter today, Rebecca Roker from Attolles Law, I just wanted to, since this is our last in the boardroom for 2024, I just wanted to thank everybody, for sticking with us for the last 2 years with our In the Boardroom series. Let everybody know that we will be continuing our In the Boardroom series into 2025, and we will get the 2025 dates and registration out to you in the next couple of days. I also want to make sure everybody is aware that we do record all of these in the boardrooms, and they are available on the WCA website. We have a really big growing library of educational materials that are on our website due to our In the Boardroom series. Just in 2024 alone, we discussed topics, related to county board rules, electioneering and political expression, renewable energy siting, county and municipal borrowing, county constitutional officers' roles and responsibilities, social media usage by counties. We have a lot of material that we have covered in the last 2 years that is available to you on the WCA website. But we are interested in hearing from you about the topics you might want to see and hear about in 2025 as well. So if there's a topic you'd like to see covered in 2025, please reach out to me at WCA or Andy and Rebecca at Attolles Law and let us know, and we can work on getting your topic into the rotation. And the last thing I wanted to say as well was we could not do this without our partners at Attolles Law. I think over the last year, you've seen Andy, you've seen Rebecca, you've seen Ben. And really, I want to thank everybody at Attolles Law for being such great partners with WCA and for all of their assistance in helping us with member education throughout the year. So with that, I am going to turn it over to Rebecca. And is that Andy standing there in the
That
background?
is that is Andy
It is
standing
Andy.
behind me.
Anyone
All
is,
right. Okay. I'm going
I'm
to
in the
turn it
middle of
over to
another
you guys
webinar.
then.
But this was so important that I come here and wish the entire county family happy holidays for the last in the boardroom of 2024 as we roll into 2025. I'm going to preface this topic by saying I think others have heard me say this before. I hope and pray that this is a law that will never be used. That's the desire. So, as Rebecca goes through this, this can be a somewhat complicated issue, and I've had plenty of conversations, as has Rebecca, over the past year or so with concerns surrounding things like shoreland zoning, county general zoning, town general zoning, what applies, what doesn't apply, how is it regulated, how is it not regulated. This is why this topic is so important, is that we hopefully have a firm foundation and understanding with our town colleagues about how this law works so we can avoid what I think would be a messy process, even though it's a lengthy process allowing us to plan, it's a messy process for town withdrawal. So enjoy Rebecca's presentation today, ask all sorts of awesome questions.
Yep.
And obviously, after this is done, if you have any concerns, if you have any follow-up, feel free to reach out to us. Otherwise, happy holidays, everybody. Let's kick it off, Rebecca.
All
Have
right.
fun.
Thanks, Andy.
And Rebecca, if I could real quick, I think I forgot to mention if you have questions during the webinar, please use the chat and Q&A feature included on Zoom, and we will be monitoring that throughout the hour.
Yes, thank you, Sarah. Thank you for the very nice introduction. And to echo Andy's words, thank you to all of you and thank you to WCA. It's such an amazing opportunity for me personally to participate in these in the boardrooms and all of the other events that we get to partner with WCA on. All right, town withdrawal from county zoning. This is, as Andy mentioned, a hot topic. It has been a very hot topic for the last year, so I think it's appropriate that we close out 2024 in the boardroom in talking about this topic. And as Sarah mentioned, if you have any questions along the way, please enter them in the chat, and we'll answer those as we go, and off we go. So, brief overview. There we go. Of when we're talking about the town withdrawal from county zoning, we really need to have a good foundation of the background and how we got to Act 264. So we're going to spend a little bit more time on that foundation and backstory than we would otherwise in talking about new legislation. The photo here, I thought this was a really cool photo. It's the Iron County county zoning ordinance, or the newspaper article announcing when it was first adopted in 1934. So just kind of a neat reference as we're talking about county zoning issues. So again, how did we get here? The photo here is of the Oneida County zoning map. This Oneida County's zoning ordinance was passed in 1933, and it was actually the very first comprehensive rural zoning ordinance in the country, and it became kind of an example for other counties and communities throughout the country. And I pulled this from the Wisconsin Historical Society. But again, as we talk about the background of how we got to Act 264, I think it's always interesting to look back and see, you know, almost 100 years of zoning history within our state. So with that, whenever we're talking about zoning, you know, in the relationship between town and counties, we always should look to what is the fundamental premise of what we're doing. And this is Brian Ohm, who is, you know, perhaps the best expert in zoning law in Wisconsin. The zoning is one tool used to implement community goals and objectives set forth in the community's plan. And then the ordinance identifies the districts and regulates the use of property within those districts to advance public health, safety, and welfare. And this one quote really identifies in italics all of the fundamental components that are rolled into the concept of zoning. So whenever our counties are taking any sort of action within the zoning realm, it's always helpful to remember to go back to these fundamentals of goals, objectives, a plan that identifies different districts to regulate, and all within the purpose of advancing public health, safety, and welfare. So as we all know, counties can only do what the statutes allow us to do. And where does the county general zoning authority comes from? It comes from chapter 5969 of the statutes. And for those of us who are involved in zoning, you probably know a lot of these citations by heart. The impact of this provision for incorporated areas of the county is pretty relevant because incorporated areas, cities, villages within the county have their own independent zoning authority. Now I'm talking about the general zoning too. The unincorporated areas, towns, it impacts unless we have those different opt-outs, which was obviously exactly what we're going to talk about. So if you are in an unincorporated area, you're a town, what are some of the existing or pre-Act 264 options or steps that a town would take in order to either be subject to the county zoning ordinance or not be subject to? So under 5969 sub 5, when a county adopts its zoning ordinance, a town has an option to opt in at that point. And many counties throughout the state first adopted their zoning ordinances in the 40s and 50s, as we saw, you know, some were even in the 1930s. And then into the 60s and 70s. And so many towns, when counties first adopted their zoning ordinances, opted in. And so you've got towns now that opted in, you know, potentially 75 years ago, who are still in and under county zoning. And that's one of the longstanding issues that towns had. Like, look, a decision was made 75 years ago to opt in to this ordinance, and now we want out. But again, that is what the statutory scheme of how a town gets under county zoning is by opting in within 5969. So one option for a town to get out of county zoning is to adopt village powers under 60.62 of the statutes. Many towns have taken this route. So it's not actually incorporating, but it's an adoption of village powers at their town annual meeting that then allows them to zone according to how a village can zone under the statutes. However, even if a town adopts village powers and creates its own general zoning ordinance, the county board still plays a role because the county board must still approve any town zoning ordinance amendments after the adoption of the village powers. So it's not a true opt-out. Sometimes towns will give pushback if they are told they need to bring their zoning amendment changes to the county board because they've adopted village powers. And that's when we have to point out that 60.62 sub 2 of the statute still requires county board action on any ordinance amendments, even if a town has adopted village powers. So in 2013, the legislature created an exception. I call it the Waukesha County exception because it really applies only to Waukesha County based on the statutory definition. And it allows towns located in the counties with at least a population of 380,000 and adjacent to a county with a population exceeding 800,000, i.e. only Waukesha County meets those criteria, to adopt a zoning code. So this allowed the towns within Waukesha County to adopt their own zoning code. And so it also requires the town adoption of the village powers. And again, it reaffirms the county board approval of town zoning ordinance and amendments. You may be asking yourself, well, didn't you just say, Rebecca, that those are the same requirements if a town just generally adopts village powers under 60.62? And the answer is yes. I mean, these are very, very similar. However, there is no town meeting or referendum required under the Waukesha County exception that is otherwise required for towns wanting to exercise village powers. And essentially, it's the politics. When you look to the political atmosphere within that community in these years, it was such that the statutory fix was the best option. So in 2015, we then saw the Dane County exception. Again, the exception being a way for towns to get out from county zoning. This exception is also contained within Chapter 60, and it allows for towns located in a county with a population of at least 485,000 to withdraw from county zoning and land division controls. And here, only Dane County meets the population requirements and still has townships. So again, this is essentially exclusive to Dane County. The safeguards that were contained within the Dane County exception include the town must adopt a comprehensive plan, the town must enact a zoning ordinance, and it must establish an official map. These safeguards essentially became the foundation for Act 264. Our impression is many towns said, hey, now we've got this Dane County exception. Why can't that Dane County exception apply to all towns? And so hence we get to Act 264. The photo here is from, it's a non-metallic mine in Chippewa County, and that is the location of the Zwiefelhofer decision, which for land use legal buffs was a key decision in zoning and planning law in Wisconsin in further developing the relationships between town and counties. And, we often refer to it as as kind of a landmark case to help us define town and county roles within the zoning realm. So that was kind of cool to actually see what it is was, or what, what topic we were talking about within that case. So Act 264, this essentially codifies that Dane County exception to towns across the state. So it is that Dane County exception extended. But however, we have, it's important to note this, again, this brief backstory. In looking at the big picture, there was lots of discussion between towns associations, the league, WCA, other organizations in trying to come to an understanding and a mutually agreeable legislative fix to address towns' issues and county concerns and all of those different comments, concerns, requests of what they wanted this legislation to look like. So the fundamental goal of Act 264 is to foster cooperation and communications between the town and the counties. And as Andy mentioned when he was standing here, if this law is never used and no towns ever withdraw from county zoning under this section, it will be a success. Because again, the goal of Act 264 was to, or is to, foster those communications between town and counties and improve relationships so towns will not feel like they have to opt out. Okay, so what does Act 264 do? In short, it created subsection 35 to 60.23. I'm not going to read through the exact statutory language, but I wanted to include it here because it is important, for referencing what the timeline is and what has to happen in a specific sequential order. The statute is unique because it became effective in 2024. However, really no action can be taken or no towns can opt out for several years down the road. So I wanted you to be able to have the actual statutory text in front of you if you ever want to reference it later. So again, Act 264 allows a town to withdraw from coverage of county zoning ordinance and county development at any time. We don't have to wait for those other circumstances like a comprehensive rezone or an adoption of a new zoning code and so forth. Towns can opt out at any time. Again, the howevers, these safeguards, the effective date is March 31 of 2024. Keep in mind, this was passed in 2023. The date, though, that a town may withdraw is no sooner than 5 years after the effective date. So not until March 31st of 2029 may a town withdraw from county zoning. So that is one of the key components, again, of that fostering of communications between towns and counties. So this long effective period is, again, intended to allow those communications to address concerns that towns may have in motivating their desire to withdraw from county zoning. Okay, so this is the timeline is again, it's unique in the statutes in that it is so specific. And we see that no later than 2 years before enacting a zoning code, the town must adopt a resolution setting forth the town's intent to enact a zoning ordinance to withdraw from county zoning and send that resolution to the clerk, the county clerk. Then no earlier than 2 years and no later than 3 years after adoption of that notice of intent to withdraw, that resolution, the town must adopt a second resolution notifying the county of its withdrawal. So again, this gap period and the reasons for the timelines are really to foster those communications and collaborations, and to hopefully resolve concerns that are causing a town to want to withdraw. The other purpose of these timelines is also to gather public input and public education, because as we'll talk about in a minute, oftentimes town residents will be very vocal in wanting to withdraw from county zoning until there's a better understanding of what those obligations look like. And once there's that education piece, towns may not want to opt out. So again, justification for those timelines is to foster communication and collaboration between towns and the county. So the big, however, and the big safeguard within Act 264, that again was this compromise between multiple organizations, is that before a town can opt out of county zoning, it must also enact a zoning ordinance that meets the requirements, or adopted under section 60.62 and meets the statutory requirements. The town has to adopt a comprehensive plan that meets the requirements of 66.1001, and the town must adopt an official map meeting the requirements of 6223 sub 6. The rationale being that a town has to do all three of these things in order to set itself up to be able to administer its zoning ordinance. Again, so before a town can opt out, it has to do all of these things in order for that opt-out to be effective. The key point just essentially reiterates what I just said. The town has to do all three of those things: adopt its ordinance, adopt the comprehensive plan, and adopt an official map in order for that withdrawal to be effective. Question of whether or how the county participates in that process. We'll touch on that in a bit, but know that even if the discussions between your county and towns break down and towns still want to withdraw from county zoning after that period of collaboration, there's still an opportunity for the county to participate in the town's process. And there's certainly an opportunity for the county to work with the town throughout the process of the town adopting its comp plan and adopting that zoning ordinance. So this is an example, an implementation example, because I don't know about everybody else, but sometimes those timelines are hard to grasp if I don't have an example. So this is an example with the fake Town of Freedom wants to withdraw from Lombardy County as soon as possible. They want out. So what does the town have to do? The town first has to adopt its notice resolution before March 31 of 2027. And that is not later than 2 years prior to enacting the ordinance, but may not occur until March 31 of 2029. Then the town must start its planning process on March 31st of 2025, which is not earlier than 2 years before the adoption of that notice resolution. So then the Town of Freedom may adopt its withdrawal resolution to include the town zoning code, its comp plan, and its official map no sooner than March 31 of 2029. So that is how the time frame within the statutes flushes out. So if the Town of Freedom wants out as soon as possible, it cannot get out any sooner than March 31 of 2029. So again, that gap period is intended to foster communications. But if those break down, this is what the timeline looks like under the statutes. So let's say that a town decides it wants to withdraw. What exactly is it withdrawing from? Under the new section 60.23 sub 35, it does not mean that a town is withdrawing from any of the items set forth on the chart. So a town cannot withdraw from county shoreline zoning. A town cannot withdraw from county floodplain zoning. Any county zoning ordinance or county development plan provisions that regulate quarry operations are specifically exempt in Act 264. So even if a town opts out of county zoning, the county or any county ordinance or development plan provisions regulating quarry operations are still effective. A town cannot opt out of any sort of county stormwater management regulation, erosion control, pelts permitting, those other items that fall under county jurisdiction. So we're talking about general zoning authority. All right, so in Act 264,
Becca,
what are,
Before
yes.
we move on, I'm sorry, there's a few questions in the chat
Oh,
that I'd
shoot.
like us to address before you move on. I think you
Mhm.
talked about the first one already about what happens if the town does not reach out to the county. And if not, you could address that. Otherwise, I think there's three other questions here. The first one being, could you explain the difference between opting out of county zoning versus withdrawing from county zoning?
Yeah, I'm sorry, I was just looking at that other comment. So I'm going to take Ken's question first. What happens if the town does not reach out to the county? Great question. You know, the point of the legislation is to foster communications. What if the town doesn't want to communicate? There's nothing in the statute that requires those communications. The county essentially can't force the town to communicate. However, many towns who are looking to opt out already rely significantly on the county for zoning administration. And as we'll talk about at the end, if a town elects to opt out and doesn't have a good grasp of what is needed in that county or in the zoning administration, chances are they're going to be looking to the counties for help. Counties are not obligated to do that once the towns opt out. So if you can get that message out to towns, we want to help you in this process. So property owners and county residents and county property owners are not negatively impacted. You know, try to foster those communications as much as possible with the towns. But again, there's no statutory requirement that that collaboration occur. All right, next question. Could you explain the difference between opting out of county zoning versus withdrawing from county zoning? That's a great question, Garrett. And even I use those terms sometimes interchangeably. And really, it depends on what context they're being used. But within Act 264, it allows for the town to withdraw from county zoning. So that implies that the town has already opted in under one of those provisions in 5969. So for a town to opt out, it must have already opted in. There's some towns out there who have never opted into the county zoning code. So for those towns, they are not under the umbrella of county zoning, and so they don't need to opt out. They're not under that umbrella already, so they don't need to get out of it. Okay. What happens if it only adopts the zoning ordinance? Who steps in if they don't do all the steps? Is the county supposed to deny them their withdrawal until all three pieces are completed? This is a fantastic question, and from my lawyer's mind, kind of the $10,000 question. What happens if the town doesn't do all of the things that it is required to do? I will tell you that in Act 264, there is no specific requirement that the town approve all of the county's actions. There's nothing within that new sub 35 that was created by Act 264 that says the county must approve the town's new zoning ordinance, comprehensive plan, and official map. However, the way that the statutes are structured, there's still a question of what role a county may play in that process. And so again, we go back to the goal of fostering collaboration. And if a town only wants to do one of the three steps, we highly encourage the county to essentially let the town know, look, you need to do all three. If you want to effectively administer zoning for your town, you need to do all three. And at that point in time, I anticipate that some towns may say, okay, we don't want to opt out. If we have to do all three of these pieces and towns really have a solid understanding of what those obligations are, they may not want to opt out. Again, so going back to that goal of fostering communications and collaborations, once there's that education piece of what is all required to actually opt out, then we may see towns that don't choose to do so. All right, does the quarrying operation include all non-metallic mining? That's a great question as well. I have to go back and look at the language of within chapter 66 in that reference. I think it's 660414. So I don't know. I don't know if that exception to the town the town's withdrawal from the county zoning, if it and then the continued application of the quarry operations does indeed apply to all non-metallic mining. So I'll check on that and I'll get back to you, David. Sarah, you want me to just keep rolling through the questions?
Yeah, why don't you keep rolling through? I think there's one or two left in the chat, and then there's now 4 questions or 3 questions in the Q&A now too.
Oh, awesome. Okay.
Yeah, just so the folks know too, you only have, I think, 4 slides left. So we will be getting through the full presentation, even though we're taking this break to answer questions.
Awesome. All right. Next question from the chat. What is the main reason why the county should not want a town to leave the county? I think the intent is to leave county zoning. I think each county may have a different reason. Again, and it's based on the dynamic of the relationships between towns and an individual county. I can say the main reason that we've seen on our end is that towns desire more local control. That is the number one reason that we hear. Why would a town want to leave county zoning? They want more local control, which is understandable, and that is, a goal for many communities. In terms of the reason why, or are there reasons why a county would not want towns to opt out? The main reason that we hear is the concern for the citizens and property owners that, if a town decides to opt out, and even though there's a statutory guide for what must happen, what if the town doesn't do that? The ultimate loser is going to be that property owner. And so, counties have voiced a lot of concern about how this is going to impact property owners and users of land if the town doesn't, essentially do what it's supposed to do. Again, that message of collaboration and communication, if We can help each other in figuring out what is required for a town to successfully opt out, then hopefully that will mitigate the risk of negative impacts on property owners and users of land. All right, next question in the chat. On the previous slide, if non-metallic mining, stormwater management, and erosion control are in general zoning ordinance and a town opts out, do these ordinances still apply? That seems awkward and difficult to enforce. Great question. So what if your county's non-metallic mining, stormwater, and erosion control are within the general zoning code? I would argue that the town, upon opting out of that general zoning, it is still subject to the non-metallic mining, the erosion control and stormwater management, or whatever other categories. It does not have authority to opt out of under the new sub 35. So yes, it may be a situation where the town has withdrawn from county zoning under the general authority, but it still must operate under provisions of that general zoning ordinance if those general zoning ordinance provisions relate to erosion control, stormwater management, the non-metallic mining. So again, to answer the question, even if a town opts out and all of these regulations are contained within the same zoning ordinance, we're still applying those provisions of the zoning ordinance that the town doesn't have statutory authority to opt out of. Next question, do coring operations include metallic mining as well? That one I know is a no. The exception for continued applicability of county mining regulations is for non-metallic mining. So it would not include, it does not extend to metallic mining. Next question, it seems there is a potential for disputes between town and county zoning for property owners. If towns do not meet all of the requirements and the county does not approve a town's opting out, essentially what happens. And this is the conundrum that really the goals of the legislation of communication and collaboration are trying to avoid. No one wants the property owner to be stuck in the middle. If a town properly opted out, if it met all of the statutory requirements, that property owner is subject to the town's zoning ordinance, even if the county feels like there's some defects in that town zoning ordinance or the town processes. If the towns opt out properly, then that property owner is subject to the town regulations. The dispute may happen where the county feels like the town didn't follow the requisite legal process. There's nothing in the statute that says what is going to happen in that situation. So I can't point to a section that says, if the towns don't follow the process correctly, this is what's going to happen. We don't know that. That is one of the uncertainties. But again, the goal of the legislation is that all of these safeguards and the long time frames are going to be sufficient to eliminate these conflicts down the line. Next question. We continue to get questions and requests for assistance from landowners in the opt-out towns here in Dane County. That request for assistance, I can't imagine what a burden it is for counties who have towns that have opted out, and then the towns are still looking for assistance. What I can tell you is in Act 264, there's nothing that requires a county to assist a town that has opted out. There's nothing requiring a county to provide guidance. Now, of course, I'm sure all of you as as county employees or representatives, of course, you want to help property owners. I mean, that's why we're in this business, as Andy says, not to make the big bucks. So we want to help people. But the question is, are we obligated to help if a town has opted out? And I say no. And some people don't like that answer because it's really easy for me to sit here in, my office in Milwaukee and say, you don't need to help the towns, don't answer the calls. That's not reality. But what I'm saying from a legal standpoint is there's no legal obligation for the counties to assist towns who have opted out. So how do we meet that delta between no legal obligation and the reality of it? Again, it's nothing but communication and fostering. We've seen I'm aware of some situations where a county and a town have entered into an agreement for shared services. That may be one option. If the town is not interested in paying the county for those zoning administration services, it's kind of like a child that doesn't obey. You have to set a hard boundary and say, well, without some sort of agreement for us to administer zoning, we can't do it. Again, super easy for me to sit here and say, but that essentially is the next step that has to occur if that communications break down.
Yeah, Rebecca, we have 9 open questions so far, and I want to make sure we provide you with the opportunity and that everybody has the opportunity to hear the remainder of your presentation. So I'm wondering if we should get off the Q&A for a while, go finish the rest of the presentation, and just let everybody know that continue to put your questions into the Q&A and chat, and we will stay on as long as necessary to get through all of the questions that folks have.
Yeah, absolutely. Thanks, Sarah. Okay, so now we're going to talk about some of the special issues. We've already touched on some of these. So this, you may be getting some of the information twice. The photo here is the Willow Creek Ranch in La Crosse County. Again, for the legal buffs, Willow Creek Ranch was a seminal case in zoning and land use law because it again, further defined that relationship between towns and counties, and even at the state level, of what preemption within county zoning or zoning and land use in general looks like. So again, for me, fun to see the actual, the actual place that was subject to, this case that within our legal circles we talk about all the time. All right, next slide. All right, so special issues. This really comes down to what does, upon the town's withdrawal from county zoning under the new provisions of Act 264, what is not changing? What is changing? What is not changing? Okay, so land divisions. If a town withdraws from county zoning under the new sub 35, a county no longer has approval or objecting authority for certified survey maps, approval or objecting authority for preliminary or final subdivision plats. And this is where this site is missing. If the town withdraws per 60.62 sub 35, the new legislation. However, there are cooperative planning regulations that may still be in effect. So it doesn't, what I would essentially tell counties that if a town withdraws, there are still some opportunities for the county to participate in that land division process. So other kind of special issues that we see, if there is land subject to a cooperative plan under the statutes, that designation does not change. The Farmland Preservation Program was a big concern, within the discussions leading up to the passage of Act 264, because the Farmland Preservation Program that's administered by DACCAP requires zoning certification in order for an owner, in order for the county's plan to comply with the DACCAP requirements, with the legal requirements for a certified farmland preservation plan. But then also, in order for a landowner to get those tax credits through the program, the county has to certify the zoning component. And the county's concern was, well, hey, if the town is administering the zoning, we're not comfortable making that certification anymore. So that is an issue that is still somewhat open based on our discussions with DACCAP to close the loop on that issue. DACCAP isn't too concerned because they're essentially taking the position that if the statutory steps within sub 35 are met, that certification should be valid. Again, that assumes that those statutory steps have been met. But for our purposes, just be aware that, within this town withdrawal discussion, farmland preservation may become an issue for more in-depth discussion in your county. So now what? I felt like in the boardroom context, I could post some things that maybe make us chuckle a little bit. These are from the town of Caroline within the state of New York. Fortunately, there were no signs about zoning wars within the state of Wisconsin, which I was kind of surprised because I know some communities do feel at war sometimes over zoning, but these just made me chuckle. So now what? Now where do we go from here? The question that people have already hit on, what if a town does not follow the proper steps in the withdrawal process? The easy answer is under the statutes, we don't know, other than Andy and I will continue to be very, very busy. But those open questions of what a county may do, what actions it may take, are unknown. The scenario that I envision is a town attempting to withdraw. It doesn't follow the steps in sub 35. A landowner goes to the town, makes an application, is denied, and raises an argument within a litigation setting that the town failed to follow the statutory process and therefore the town zoning ordinance is not effective. That's how I see all of this playing out. So in that situation, we're going to see litigation that is essentially prompted by a property owner. Well, what if we don't want to wait that long? There is an option that someone or a county or some entity could bring a declaratory judgment action and say, Town of Freedom in withdrawing from county zoning didn't follow the steps properly, and therefore the town zoning ordinance in their administration is not legally effective. But again, that requires a town to follow or attempt to start to follow the steps and then fail to follow those steps. So there's nothing we can do right now in terms of seeking, any sort of declaratory judgment action, based on the new legislation. So again, a lot of unknowns if a town does not follow those proper steps. Again, to sound like a broken record, that is why the goal of the legislation is to have those communications and the collaborations between the town and the county. So either we can fix the problem or the proper steps are indeed followed within that withdrawal process. Okay, so what do we know? We know that the town must comply with the requirements of 6023 sub 35, i.e. Act 264. We do know that a county is not obligated to assist a town in that process. As I mentioned before, I know there's counties who are asked for assistance all the time, but know that the county is not obligated to assist. The next point, again, easy for me to sit here and say to all of you, but once a town withdraws, a county has no legal obligation to help or to let that town back into county zoning, or to provide any administration services. I know there's counties out there who bend over backwards in trying to assist towns in the comprehensive zoning process, and who go above and beyond what is statutorily required. You're not required to do that under existing law, and under the new sub 35, a county is not obligated to do those things. But again, I understand that in just the process of being a public servant, we want things to go well, and we want to have that smooth process. But just know that the county is not obligated to, and that component of a county not being obligated to let a town back in, we don't know what that looks like. There's no inclusion within Act 264 of what that process is or what it looks like to allow a town back in. Again, the reason that communication is so important prior to the town opting out. And I think that communication is really going to need to be a hard look at, all right, towns, do you really understand what it takes to administer zoning? Who's going to take the phone calls? Who's going to be doing the reports? Who's going to be doing the presentations? All of that work that all of our zoning administrators and staff do every day. I think if towns really have a good understanding of what those responsibilities look like, then there may be not so many towns who want to withdraw. But again, that all comes back to communication and collaboration. One item that I did not include on here that I wanted to mention is, in terms of the what next, there are, again, many counties that assist towns right now in their administration of zoning. So again, we had the Dane County question of towns that have opted out or never even opted into county zoning, who look to the county for help. No legal obligation to do so. And in some instances, there will be an agreement for providing administrative services. So a county will essentially contract with a town to assist in administration of that town zoning ordinance. At that point, the county gets paid to do what many of you are doing every day anyway. So I try to put that out there as a potential positive that may come from this is, if a town decides to withdraw and then decides it wants to come back in or decides it needs help, maybe that's an opportunity for the county to say, yes, we want to help, but you know what? This is very taxing on our county staff. And so therefore we need some assistance to be able to provide that administration, that enforcement, all of that time and capacity, and then negotiate with the town. I think if that happens, we may see some more cooperation from towns because at least in my experience, many towns do not feel that they should have to pay for those county zoning services. So it'll be interesting. It'll be interesting to see what happens, as this process unfolds. So, Sarah,
Rebecca, we have at least 18 questions.
Oh my
that are
goodness.
open. There's 13 in the Q&A, and
Okay.
there's another 5, maybe 6 that are in the chat.
Okay.
Where we last left off, might I recommend starting with the Q&A because some of those folks have been waiting for a while.
You bet. Okay. Sarah, you're going to have to help me pull those up because
Okay.
on my screen I have the chat, but I don't have the Q&A. So can you just read those off to
Sure,
me?
I will read them. Okay, the
Okay.
first comes from Jason.
Okay.
County point of view, with multiple towns wanting different levels of regulations, is the expectation that a county should have separate regulations for each town? If so, that will be difficult to implement.
Yeah, I would not recommend that a county have different regulations applying to different townships. I'm not even sure that would pass legal muster under Chapter 5969. So if that is what a county is being asked to do, um, again, from a 10,000 foot perspective, I would not recommend doing that. If it's broken down by districts or different categories that some may only apply to one township, that may be an option, but I would not carve out separate regulations specifically for different townships within the context of your ordinance, your county ordinance.
All right, next question from Daniel. How about land division regulations? The Dane County Act included land division regulations.
Yes, so Act 264 does include those land division regulations as well. And so if a town opts out under sub 35, it is also opting out of elements of the county's land division regulations as well. So again, duplicative of the Dane County exception.
Okay, and then from Chris, for towns that have not opted in but would like to regulate their own land division ordinances, what would their process be? It seems like this is a gray area.
Yeah, it is a gray area. So if a town, well, if a town has never opted into county zoning, we're talking about the county zoning code within 5969. Land division regulations fall under a separate statutory scheme. So the question of whether a town can adopt its own land division requirements essentially is separate from whether the town has opted into zoning. The extent of town authority to adopt land division ordinances, if they haven't opted into county zoning, that I don't know. And this is when I wish Andy was here because he probably knows off the top of his head what town's statutory authority is to adopt land division regulations. And I'm just not that familiar with what town's authority is. I know they have some authority to adopt land division regulations, just the extent of it, I don't know.
All
But
right.
here's where my phone number and email address is on the screen, so people can always, we can follow up. I can certainly ask Andy and then, provide a response through WCA.
All right, from Jeff. Could a county pass an ordinance which says that if a town withdraws and then subsequently wants to rejoin county zoning, they must pay a rejoining fee?
The county could pass it. The question is whether it would be enforceable, or it would pass statutory muster. Right now in the statutes, there's not any prohibition against a county adopting such an ordinance. But again, we always have to look at what authority is a county given, because counties don't have the same scope of rights that other municipalities do. We can only do what we're given statutory authority to do. So the question is whether the county has statutory authority to pass that type of ordinance. Based on just what I know right now, without looking and doing a deeper dive into the statutes, there's nothing in 5969 that grants that specific statutory authority to counties. However, given the authority that counties do have within 5969, I think an argument could be made that, yeah, it is broad enough where a county could pass that type of ordinance. It would have to be carefully drafted and it would have to relate back specifically to the county obligations within 5969, again, to establish that basis for that ordinance in terms of further protecting the health, welfare, and safety of the county. So yeah, I think it would have to be carefully drafted, but yeah, I think I think a county can look at that as an option.
All right, from Ben. If towns intend to leave county zoning, what incentive is there for collaboration?
Great question. It's a kind of a chicken and the egg question. If they want to leave, why would they talk to counties? And they don't have to, as to Ken's question earlier, there's nothing requiring that collaboration. However, we hope that it happens. And again, Act 264 will be successful if towns never opt out under it. But to that question, if a town really wants out, there's nothing in Act 264 that forces that collaboration. And that's unfortunate, but it's really hard to legislate cooperation. And so that's why, again, it's the elements of the statutes, in terms of the waiting periods and in terms of what towns have to do are mechanisms to try to encourage that collaboration.
Right. And again, we know we are past our ending time of 1 o'clock. Rebecca, are you okay with staying on and continuing to answer questions until we get through them all?
Yeah, absolutely.
All right. And again, for those of you who may need to leave because you have other obligations, this webinar is being recorded and will be placed on the WCA website. All right. From Frederick, can a town decide it doesn't want any zoning?
Yes, in a few different ways. It can, if it never opted in to the county's zoning ordinance upon creation, then it doesn't have zoning if it doesn't adopt its own code. One option that we didn't talk about yet that I think is important is within 5969 sub 5, it sets forth an opportunity for a county to adopt a comprehensive revision of its zoning code. If a county does a comprehensive revision, that creates another opportunity for a town to opt in. So again, I mentioned that a town can opt in upon creation, which many did in the 1940s, 50s, 60s, and 70s. But if a county does a comprehensive revision, that creates another opportunity. So throughout the state where we've got counties with unhappy towns that don't want to adopt village powers and don't really want to do anything except complain about the process, we've advised, counties, maybe you want to look at doing a comprehensive revision to your code because that will give towns an opportunity to never opt in. So what? From my perspective, it eliminates some of the air from those town sales because if the towns elect to opt in upon that comprehensive revision, you opted in. If they elect not to, then the towns are on their own. And then at that point in time, a town is under no obligation to have its own zoning ordinance. In fact, real quick, on the cover of the presentation is a map from the UW Extension for Land Use Planning of color coding the areas throughout the state that either are municipal zoning, so city village, county zoning, town zoning, or no zoning. And surprisingly, there are still a lot of areas throughout the state where there is no zoning, which again, it surprises me in this day and age, but we do have them.
All right, from Jay, if and when a town was to opt out, what is the process to opt back in later down the road?
We have no idea. There is nothing in Act 264 or in the statutes that gives us a glimpse of what that process looks like. We can look to the process we have already within 5969 sub 5, and I think when faced with that question, I think our legal guidance will most likely be look to that existing process and follow that process. But the short answer is Act 264 did not include any guidance on how a town opts back in if they choose to withdraw under sub 35.
Right, and it looks like that was Jack's question too about how do towns opt back into county zoning. So move on to Jeannie's question. What if the county has a standalone subdivision ordinance and it's not part of the general zoning?
Great question. Under the provisions of Act 264, even if the subdivision ordinance is separate, it is still a town is still deemed to have opted out of that upon its withdrawal from county zoning. Again, having follow the process that is in the new sub 35. Similar to the question of what if a county ordinance has everything in one ordinance, if it includes stormwater management, erosion control, POUTs, etc. The structure of a county ordinance is really irrelevant. We look to what sections would be no longer applicable to a town.
All right, from Benjamin. Does the county lose its objecting authority for land divisions that involve shoreland areas as well?
No. The easy answer is no. The county does not lose its objecting authority for land divisions that fall within the shoreland.
All right, then it says land division review is no longer required at the county level when a town leaves zoning, question mark?
That is my yes. And this is one that I've had lots of discussions with many of you on the call. And what is the interplay between Chapter 236 and a town opting out under sub 35, 60.62 sub 35. And the way that Act 264 reads is that a town may withdraw from that subdivision authority, if you will, county subdivision control authority. However, there's other provisions within Chapter 236 that still allow for county participation and review. So I think that the easiest answer is yes, a town may withdraw from that land division authority, but it's not as complete as a withdrawal from county zoning because there's still things left over in Chapter 236 that that require the county to participate.
From Ben, how often can a town request to leave county zoning?
There's no limit. There's no number set forth in the statutes. And this is, again, that the mechanics of how is all of this going to work? How many times can you get married and divorced? There's no limit. But I could see how a county would get very frustrated if you've got a town who withdraws and then comes back and then withdraws. And again, the ultimate loser is going to be the property owner and citizens. But again, to answer the clear answer to the question is there is no limit within the statute.
All right, then in the Q&A side of things, let's say just the last thing is just a note that the map referenced on the opening slide doesn't appear to be current for their particular county.
Oh, interesting.
Yeah.
We're going to have to talk to our friends at the UW Extension.
Yeah.
Does it say what county that is? I'm curious.
Oh, let me see.
I can go back to.
I don't know what county that is.
Okay.
Um,
No, that's really interesting. And I always have to be careful when I stick stuff like that into a presentation, because obviously I want to give credit where credit is due.
okay, so it's Burnett County, and another county has indicated it's not current for their county either.
Okay. All right. Well, thank you for that heads up on that. And that's a really good point, other than correcting. We want to make sure that it's proper information presented. But that's a good indication of how quick this stuff changes too. One of the photos I had that I ended up not including was a land use map that was generated originally by Sewer Pack and then hand drawn for I think it was the town of Grafton. 1 year later, it had become a village and it was completely different and hand colored completely different. And in just that 1 year time, how significantly things can change. And when we're talking about land use, those are some really big changes. And again, the objective of proper zoning and planning is consistency, not only in decisions, but in land use. And when things change that quickly, we have to ask ourselves how, is consistency being impacted?
Yeah, and we heard from Richland and Eau Claire as well, indicating it's not correct, and some of them have reached
Wow.
out to the folks asking for the maps to be changed.
Okay.
Okay,
Oh,
well,
great.
we are now back to the webinar chat. So
All
I don't
right.
know if you have that available to you or not, but we are at 12:36 p.m. with John's question. That's where we
Okay.
left.
12:36. Okay, let me just
And
get
then
that.
we'll have to go back to one more question that just came in the Q&A.
Okay, awesome.
Are you ready? All right.
What about towns that never opt in to county zoning? Great question again. If a town never opted in under 5969 when the county zoning ordinance was created, or upon that comprehensive revision, the town is not in, so there's no process of withdrawing. And a town that never opted in would not have to opt out under the process set forth in Act 264. Okay, how would long-term agreements based on county zoning districts, farmland preservation agreements, and overlays be affected if a town opts out or develops their own conflicting ordinance? That is a really good question. So, how long would long-term agreements, such as farmland preservation agreements, would those continue to be effective if the underlying ordinance changed? And that's a DAC question, first off, because DAC is the decider of whether, at the end game, whether the property owner is essentially entitled to the tax credits, if they have complied with all of the program requirements. I would, without looking at the DAC policies and the administrative code, I would say that the agreement term would continue, and it would continue to be effective, even if the underlying zoning had changed. Because I think a court would say that, that owner and the parties bargained that agreement, that contract, at the time when the designations were X. Just because they changed to Y doesn't mean that that bargain is no longer sufficient. Now, that being said, my guess is there's something in the agreement that makes the agreement contingent upon consistency or continued, I was going to say continued sameness. A provision in that agreement that requires the zoning not change. So if there is that type of provision, then those agreements would terminate by their nature. And so those are, certainly things that may be of concern for owners who are within a township that wants to withdraw. How is that withdrawal going to affect their long-term farmland preservation agreement? Okay, next question. What if your county has a separate subdivision code which specifies certain obligations? Whoops, I lost it. For CSMs. Again, it doesn't matter if there are separate ordinances. We look to what the topic of those ordinances are. So just because it's a separate ordinance and the county, or I'm sorry, the town is withdrawing from the general zoning ordinance, and whatever is set forth in sub 35, doesn't matter how we lay out our ordinances. Now, the question of the impact on obligations relating to CSMs, that I don't know. I believe, but I'm not sure. But when the town does the withdrawal and it is no longer subject to the county land division restrictions, it also applies to CSMs. So we're talking about subdivision plats and CSMs. I don't believe there's a carve out for CSMs and for county to continue the review obligations for CSMs. All right, next question. I can also see a situation where a county asserts jurisdiction on a resident in a town that has not withdrawn properly and attempts enforcement. I think that is a great point, that if we have a situation where a town attempts to withdraw and doesn't do so properly, and then a situation occurs where the county feels enforcement is necessary, at that point, the county could argue that it does have jurisdiction to enforce because of the town's failure to follow the statutory process in withdrawing sufficiently. So yeah, I think that is a situation we may see. And again, that's going to, create some tensions, not only between the county and the town, but with the property owner. But again, with those very general facts, I think the county would have an argument that, yeah, it does have enforcement authority because the town didn't follow the statutory steps required to withdraw. All right, next question. Can this presentation be emailed? Sarah, we can do that, right?
Yeah, I can check on that. It will also be posted on our website at wicounties.org. And then under events and past event materials. So I would have to check with the person who runs registration for this, whether or not we have the ability and can extract everybody's email addresses. Otherwise, I would say the quickest way for folks to access this is as soon as it's done, this webinar is completed, I will download the recording. I will send it off to get processed, and hopefully the recording and the PowerPoint can be placed on our website. Usually it's pretty quick by the end of the day. Sometimes it's the next day, depending upon if the right people are in the office or not, but it will be available on the website as soon as we can possibly make it available.
Awesome. Maybe we should put a disclosure when we post it that the map on the cover page is not up to date, because I'm getting a little sensitive about that. All right, next question. Oh, it's not a question. Hi, Trisha. Just saying hello and good to see you. Good to virtually see you too. I remember those cases that we worked on very well. In fact, I was just thinking about them when I had a cross paths with one of the other attorneys involved. So it's great to see you too. I love my friends in Washburn County. All right, next is, it was just a comment by the WCA. Question, I believe current law requires counties to approve town zoning ordinances and their amendments in counties with comprehensive zoning. That is correct. Does the new law change that for existing towns with their own zoning or for towns that opt out under Act 264? Wonderful question. And that is a big question mark that we are still looking at. What I can say is that under Act 264, there is no requirement that the county approve the new town zoning code, comprehensive plan, and official map. If a county has concerns about the sufficiency of those town documents, I think that's an opportunity for discussion. But again, there's nothing within Act 264 that sets forth a direct obligation for counties to approve those documents. Next from Ben. Same with Eau Claire map. Incorrect. Last question, can a town withdraw from zoning but not from subdivision and land division? That's another great question. I don't think so, because under sub 35, it sets forth the requirements for that action of withdrawal. And it doesn't allow piecemeal withdrawal. So I think if we're just operating under sub 35, the answer is no. However, there may be other options within the statutes that a town can have its own, I don't want to say independent, but have more control over subdivisions, and those would be in either chapter 60 or chapter 236. But I'm not sure on that. Sarah, I'm thinking maybe we should do another in the boardroom or presentation on Act 264 and just subdivisions and land divisions, because we've got a lot of great questions on those topics. And I don't have a whole lot of answers. And so that may be an opportunity for us to continue on into 2025.
All right. We have one final question that is in the Q&A.
Okay.
It says, if a county completes a comprehensive revision and a town does not adopt the new ordinance, what rules apply?
The rules in terms of the town is not subject to that general county ordinance. So the county does not have to send, the rezone notices to the town. It probably still would. But the town is essentially not part of that county zoning process with respect to the general zoning. Even if a town does not opt in, if there's a comprehensive revision of the shoreline, that still applies. Floodland still applies. It's only that the general zoning ordinance that we're talking about.
All right, so that completes our questions and our Q&A for today. Rebecca, thank you so much for sticking around, as well
Absolutely.
as of our participants that stuck around in 25 extra minutes with us as well. Before we conclude, I just want to mention that, again, we will be continuing our series into 2025. Our next In the Boardroom will be on January 22nd. Rebecca, I think, is that going to be you again? Where we're going
I think
I
so.
think we're talking about Lake District issues and the proper organization of Lake Districts.
We are, yeah. And when Andy and I were talking about, what topics we see, we've had this sudden bubbling up of Lake District questions. And one of my favorite counties who I love to assist is dealing with one right now, and we've had other questions from others. So we thought this would be a good topic, not only because it seems to be a trend, but from a legal standpoint, the power of a lake district is pretty extraordinary because it essentially is a new municipality with taxing authority, and the county does play a very important role in that creation process. So even though I think we have over 200 lake districts in the state already, we thought this was a good opportunity to kind of bring these issues back to the forefront and talk about them. So I believe Andy will be joining me for that one as well, unless he gets pulled away. But hopefully he will be here for January.
All right. So again, thank you everybody for joining us for today's In the Boardroom. Again, we will see everybody back on January 22nd. Want to wish everybody happy holidays and a great new year.
Thank you, everyone. Thank you, Sarah.